seated, please. We have three cases on the calendar for argument this afternoon. The cases will be heard in the order in which they appear on the calendar. The first case has been rescheduled, so we'll hear Rochell versus the State of Florida. Is counsel for the appellant ready to proceed? Please come forward.
Good afternoon. May it please the court, Mr. McCoy. I would like to reserve 2 minutes for rebuttal of my time, please.
All right.
There were actually 5 issues, 3 of which have to do with the trespass, and then there are 2 others. I'm going to briefly touch on a couple and then go right to the trespass. In the state's answer brief, the state argued that the exclusionary rule should not apply to probation revocation proceedings. I understand that this very court has certified that issue to the Supreme Court in the Peters case, so I'm not going to spend any time arguing that issue. I, of course, believe, and Mr. Rochell believes, that the exclusionary rule, of course, should apply to probation revocation. And I'm willing to argue about that if there's time. I would like to move on now to the monetary. He was found in violation also of his monetary conditions. The defense never argued that Mr. Rochell was unable or did not have the ability to pay. But he was doing at all times what his probation officer told him to do. The probation officer testified at the hearing that it was his policy, the probation officer's policy, not to require payments from a probationer until they had filled out something called the Offender Financial Obligation Agreement. Mr. Rochell reported in November, and he didn't fill out this agreement with his probation officer until February. As soon as he found out the amount of his payments, which was $168 a month, and the next payment was supposed to be due in March, that was fine with Mr. Rochell. Indeed, he came in early, I think on March 2nd, and paid $100 ahead. To me, this shows good faith in the fact that he was totally willing to pay his obligations. His probation officer is his contact with the system. His probation officer wasn't requiring him to make any payments until February, and he started to pay. And I think the court erred in finding that a willful and substantial violation of his monetary conditions. Next, I want to touch briefly on the substantive case, although the state, I don't believe, ever filed any information on it. But ultimately, Mr. Rochell was found guilty of constructive possession of cocaine. There were 2 men in the truck. All this is in my brief, of course. There were 2 men in the truck, so there's no inference of knowledge. The state has to prove it under a theory of constructive possession, which means they had to show that Mr. Rochell had dominion and control and knowledge of the presence of the little black film canister that was on the floorboard of the passenger side, and Mr. Rochell was driving the passenger side of the little pickup truck. Mr. Rochell submits that there was no evidence that he knew that the canister was there. Both men denied knowing it was there, and it was a company truck. He was allowed to use that for work, and he was using it apparently after work, but that was a company truck, Paget Pools, something like that. The state, in its answer brief, makes much of a statement that Mr. Whitford testified at the hearing that Mr. Rochell made. And when asked about it, I'll give you the verbatim quote. This is Mr. Whitford. He's asked about, did Mr. Rochell make a statement to you? He goes, the only thing I can remember is he was like, something about he was on probation or something. And the state attorney asked him, and what did that mean to you? I guess he wanted me to take it. What do you mean, take it? Take the charge. And that's the extent of that conversation. It's pure speculation on the part of Mr. Whitford what Mr. Rochell meant by that. It's much more likely that he meant, oh my goodness, here we are stopped, we're accused of cocaine possession, I'm on probation, I'm in a lot of trouble. And I would submit to the court that that's all he meant by that. Also, the timing of that statement is after the men had been informed that they were under arrest for cocaine possession. That's when he made that statement, such as it is. I would submit that does not tend to prove that Mr. Rochell knew that the canister was there or what was in the canister. They had already been arrested for cocaine possession. So the timing of that...
Didn't Mr. Whitford testify that was not his cocaine?
Yes, he did.
Would that be sufficient? There's no reason, because you're not trying to seek suppression of anything here, but I mean, this officer obviously had probable cause to arrest both of these men for the cocaine.
Yes, there was a dog alert.
Neither implicated the other, and there had been a dog alert, and it was discovered, which gave him the opportunity to conduct the search. But something more than probable cause is required, even though we're only involved with a probation revocation hearing here.
Yes.
I suppose. But doesn't Mr. Whitford's testimony that was not his cocaine, in light of the fact that the only other person in the car was the driver, the defendant here, provide a sufficient basis to competent substantial evidence from which the judge could conclude that the violation occurred?
If it was completely unrebutted, I suppose that's true. It was my understanding that Mr. Rochell denied any knowledge of it also, and I believe he made a statement like that to the officers, one of the officers involved. And, of course, he pleaded not guilty to this violation.
He didn't. Mr. Rochell didn't implicate Mr. Whitford, though, did he?
No.
I'm most interested in the justification for the stop, which I guess you're about to come to next.
Yes.
And one concern I had in trying to understand specifically what the factual context is for the determination of whether or not there was a founded suspicion for the stop, I saw somewhere in here that in fact this apartment complex issued stickers to residents of the complex that they could affix to their automobiles. I think I saw that. Am I incorrect about that?
I don't think so, not in this case. I don't remember anything about stickers. I know that there was a 5-minute policy that the management of the complex and the police
Well, what if people live there? I mean, there's not a 5-minute limit on people who live in the complex, is it?
I would hope not.
Well, I mean,
being out in their own parking lot.
I guess my question is, what was there in the circumstances here to lead to the, and I'm going to ask Mr. McCoy to answer this too, but what was there to suggest that the occupants of this vehicle didn't live in the complex?
I don't know. It's my contention all along that this is really an unfounded stop. The men didn't do anything. They were just simply there in the parking lot, legally parked for 10 or 15 minutes, and then they left. And right after the stop, right after they were stopped 4.3 miles away, across town, Mr. Whitford, when asked, got on the phone to his sister and said, "Here, tell the officer that I was just there visiting you." And that was established right away, that he had indeed been visiting his sister at the complex. So to my mind, and this is one of the reasons I requested oral argument in this case, is that the men didn't do anything. At the hearing, the state made much of the fact that they sat in the truck for 10 or 15 minutes and didn't interact with anybody, as if that was suspicious. Now, I would maintain that it would be much more suspicious if several people came and went from the truck, because that would be very indicative of some kind of drug activity. And that didn't happen in this case. They were just sitting there.
That doesn't make it any less suspicious that two people sitting in a truck are just sitting there, right? I might agree with you that it would be more suspicious if there were people coming and going from the truck as if drug transactions were.
Yes, Your Honor.
And I think you make a good point there, but it doesn't make it any less suspicious that two people are sitting in a side of truck, not moving, not doing anything.
One was talking on the telephone.
As it turns out, yes, at the hearing it came out that one of them was completing a phone call.
And the officer saw that he was on the phone? I mean, was it
apparent? I can't remember. You stumped me with that one. I can't remember. I don't think the officer saw that he was on the phone, because he kind of kept his distance because he was undercover.
Wasn't it, maybe it wasn't a sticker, was there some testimony about residents having been given a pass of some sort?
I know that there are some cases where they do that in the apartment complex.
Okay, well, if you're not familiar with anything like that in the record, that's fine.
What about the no trespassing signs? Were they totally visible to anybody who might enter?
There were apparently plenty of no trespassing signs, but of course there's a question of whether they meet the requirements of the statute, which are quite specific. The letters have to be at least 2 inches high. The owner's name has to be on there, and in the record, there was a picture of a no trespassing sign. Did not have. It was just kind of a generic, no trespassing sign. Did not have the owner's name on there. And the trial counsel and I argued both that there was not enough signage, and it didn't meet the requirements of the statute to provide constructive notice to these men that they were trespassing. And certainly, nowhere in the complex did it say that if you are lingering more than 5 minutes, you are considered trespassing.
But if they'd gone to pick up the nephew, who then didn't go with them, then they hadn't gone with any, I mean, there wouldn't have been a trespass. They had a reason to be there. So even if the trespassing signs had been all over and they saw no trespassing, they still would have gone in
Yes.
to pick up the nephew.
Mr. Whitford's sister lived there. And Mr. Rochell testified, that he visited someone, too, that lived next door to Mr. Whitford's
But
sister.
none of that really matters, does it? I mean, the only thing that really matters is what that officer observed. Because
Yes.
those observations were the only factual circumstances that provided a basis for the stop.
Yes, and I argue that it's not enough. It's not enough. There are cases that are cited all through my brief that, mere presence on the property is not enough. There's got to be something else. If the state was proceeding on the theory of that this is an unenclosed curtilage of property, then there has to be evidence of some intent to commit some other crime other than trust.
Now, this was during daylight hours, wasn't it?
Sorry?
Wasn't this during daylight hours?
5:25, I think, in the afternoon. So it wasn't late at night. The officer never approached the men. Some of the cases about trespass, many of them had to do with flight. When the officer approaches, the people run away. And that adds, another suspicious circumstance. There was nothing like that here. The men were just sitting in their truck. And as it turned out, they were finishing a phone call. And as we know, watching the news, studies have come out that if you're on your cell phone while you're driving, your odds of having an accident are the same as if you're impaired. And so, in a way, maybe he was doing people a favor by staying in a parking lot until he finished his phone call. And I would argue, too, what could he have done differently to avoid being pulled over? I guess just left more promptly. But they were just sitting there, legally parked. This is why I requested oral argument on this one. I just find that hard to understand. That would be enough to provide reasonable suspicion for a traffic stop 4 miles across town. The officer called in other units, had them follow him.
But that's not relevant, is it? What's relevant is whether or not there was founded suspicion of two people sitting inside a truck in a parking lot in which the police officers have been told by the owners, arrest anybody who's here longer than 5 minutes. They don't have our permission to be here, and they're trespassing if they're here, and we want them arrested. Because that's what the record does show, right? The owners were very vigilant about exercising their private property rights and precluding trespassers on the property. That was a high crime area.
That is totally their right. But the touchstone of the trespass statute is notice. If the people do not have notice what constitutes trespass, then there is no trespass.
There was extensive signage on the property, as you said.
But none of it mentioned the 5-minute policy. I would submit that the reasonable person, the average reasonable person, would not think that lingering 5 minutes in a parking lot after you've legitimately visited somebody would constitute trespass and would subject you to being pulled over across town. It just doesn't seem like it's enough. If they were playing loud music, or as I said earlier, if people had come and gone from the truck, that would be suspicious. But just sitting in the truck and then pulling away and driving 4 miles across town without committing any traffic infractions or anything like that, it just doesn't seem to justify a Terry stop.
You're into your rebuttal time.
Then I'll stop.
All right.
Thank you.
Good afternoon, Your Honors. Please, the Court, Charlie McCoy on behalf of the State. Your Honors, I want to focus first on the facts that do show reasonable suspicion of trespass. And then I'm not going to gloss over the State's position on the exclusionary rule, although I have to admit I was not aware of the Peters case, which perhaps was decided after we briefed it. I'm going to look at that after we go home. The facts of what the officer observed, of course, we've discussed, but overlooked that 5:25 in the afternoon is a fairly common time to visit, and if you were there with the intent of visiting somebody, you would think that the officer would have seen at least one person leave the truck to go somewhere in the apartment complex within the 10 or 15 minutes the officer said he observed them. Of course, neither of the two got out. Now, something that was only mentioned in passing, I do want to emphasize that the observing officer, the undercover officer, did have, or is imputed with the knowledge of the police department, that this was essentially a high-crime apartment complex, high-crime area. And they worked the apartment complex around the clock. and there was a frequent trespass complaints, and of course the experience of the police officers was that the trespass is often a prelude to a drug deal. Now, I'm not going to argue there was reasonable suspicion of a drug transaction by any means, but I think there was reasonable suspicion of trespass. Now, the fact that maybe the state couldn't have proven a criminal charge of trespass is irrelevant, unless the total act proof goes all the way down below the level of reasonable suspicion. And
So the police car was already in the parking lot surveying when this truck drove in?
it was some distance, but in a parking lot.
But it saw the truck drive into the parking lot? I mean, does the evidence show that?
I don't recall if they actually saw him drive in, but the officer said he did watch them for 10 or 15 minutes.
Yeah, but I didn't know whether maybe the question then becomes, did they watch him go up to the apartment, or were they there when they may have walked up and come back down and then?
I don't recall the officer saying that he saw the truck actually pull in, but the truck was there. He could see two people in it, and nobody came or went for the 10 or 15 minutes. And the reason, of course, the officer didn't reveal himself at that point was he wanted to stay undercover. That was the officer with the canine dog. But I think it's significant that we're not dealing with just, a typical commercial establishment or anything like this. This was, in effect, a high crime area, and that knowledge has to be imputed to the observing officer. So when you take that, plus the fact that 5 o'clock, 5:30 in the afternoon is a common time to visit, and you would assume that if you pull up, you would get out and go check to see if whoever you were visiting was there. But I also want to move on. So those facts, I think, establish reasonable suspicion, but I also want to address this signage question here. Obviously, they're concerned with the legal adequacy of the signs to establish trespasses, because this trespass statute allows you to prove trespass to an unenclosed curtilage if there's legally sufficient signage, absent actual individual warning to the person, which we don't have here. And it does appear from the record that there were some technical deficiencies in the signs. But that doesn't mean that the presence of the signs themselves don't contribute to the reasonable suspicion. Those people saw the signs. They were right there by, one was right there by one of the entrances. If you recall the photographs that were put into evidence as defense exhibits, there's one of the main entrances, a big sign that says Village Green, and right next to it's a no trespassing sign. They knew they weren't supposed to trespass. Now, whether that was legally sufficient to sustain criminal charges of trespass, we can argue over that, but it's irrelevant, because all we're looking is what reasonable suspicion. And again, they were never charged with trespass, either criminally or as a ground for revoking probation. It was the cocaine possession and then the failure to meet the monetary obligations.
Mr. McCoy, what was there that this officer saw?
Saw them?
No. What was it there that the officer saw that would have caused him to have suspicion that these two men were anything other than two people who lived in that apartment complex?
The fact that they sat in the truck for 10 to 15 minutes and nobody got in, came or went. I think why would you sit at 5:25 in the afternoon? I'm not saying it's unlawful to do so, but why would you sit in a presumably hot time of the day? I don't remember what time of year it was, but in your vehicle if you lived there.
Maybe to finish a telephone call. I don't know.
Well, the point is the officer, of course, couldn't. There any testimony he could see into the windows well enough to tell exactly what they were doing. And but you still have to put what he saw in the context of his knowledge about the apartment complex. So I think that is part of what factors into reasonable suspicion here.
Well, is there something in this record about a pass or a sticker or anything like that you're familiar with?
No, I don't recall anything, Your Honor, because I would have put it in there and then I would have mentioned it, I think. There was that 5-minute policy, but let me hasten to add there that even with all their complaints about the legal adequacy of the signage, there's nothing in the statutes that requires somebody who has a 5-minute policy for trespassers to post that as part of the signage to establish a trespass offense. I do want to emphasize, though, the state's point that apart from the questions that apparently this court certified in Peters, that if you look very closely at the Scarlett case by the Florida Supreme Court, it does not say that the exclusionary rule always has to be applied in probation revocation hearings, assuming, of course, unlawfully seized evidence. What it says, and I want to quote it because I think it's important. It just says that the U.S. Supreme Court's case in Scott, Pennsylvania Parole Board versus Scott, does not preclude the applicability of the exclusionary rule. What does not preclude does not necessarily mean you have to follow it. And to me, it's somewhat of a puzzle why at least 4 of the district courts since Scarlett have said the rule always applies when the evidence is unlawfully seized. And the state has suggested, and it may be somewhat of a moot point in light of this Peters case, that what they've really allowed there in a very closely split 4-3 decision over a very blunt dissent, that was carefully chosen language. And really, although they haven't said so in so many words, it's actually a discretionary decision by the trial court. But with that, I'm going to move on to mentioning just a couple of the factors that the trial court, if you agree that it was a discretion, the trial court had the discretion to suppress the evidence, assuming it was unlawfully seized. I would just point out that the evidence wasn't seized from a person, home, or office. It wasn't even seized from a personal vehicle. It was an employer's vehicle that he had permission to use. As I read the record, he was finished with work and was doing sort of an errand. I'm not sure he had the permission to use it as a private vehicle, like taking all the way to home or whatever. It didn't involve a confession or incriminating statements, no allegations of coercion. Obviously, it was a drug dog alert as to tangible evidence as to cocaine. And this goes on to, Judge, I think it was your question about what was the evidence of constructive possession. Well, the strongest evidence, of course, is the passenger's statement that I thought he meant for me to take the charge. Regardless of when it's said, the passenger who heard the words and was right there was the one who testified that he thought that Mr. Rochell was asking to take the criminal charge for him because Rochell was already on probation. That's very damning. I think that's probably the single strongest piece of the state's evidence of his knowledge that there was, I guess, crack cocaine in the little film canister. Also, it was a small truck. It was a Mazda mini truck in which the floorboard of the passenger side was accessible to the driver. Now, I will hasten to add that under those facts, the prosecutor, I think, commendably decided not to bring criminal charges because it would have been a constructive possession case and there just wasn't anything strong enough to prove knowledge beyond reasonable doubt. But here we're back down to a preponderance of evidence standard for violating probation. So we're 2 levels down from the standard for a criminal conviction, and the court found that its conscience was satisfied that Mr. Rochell knew that there was cocaine in that canister, in effect. And, Judge, I think it was you that pointed out that Mr. Whitford, the passenger, denied that it was his cocaine. And, of course, Mr. Rochell, when he says, well, it wasn't my cocaine, but he didn't implicate Whitford. Well, the court was the fact finder. He could believe either witness. And really, those statements are not ones that are so much capable of factual proof or not, but of credibility determination, which, of course, is the domain of the trial court. So I think what you had here is you had Mr. Rochell's words saying, take the charge for me, which even the passenger at the time thought meant take the criminal charge because I'm on probation. And you have the passenger's denial that it was his cocaine, which the trial court's fact finder was entitled to believe on a credibility basis, nothing else, over Mr. Rochell's denial that it was his. So yes, there was competent, substantial, legally sufficient evidence, at least rising to a preponderance, which is all the state had to show for purposes of revoking probation. And the last point I want to make, Your Honors, is that when you get over to the monetary obligations, keep in mind that there was the court's order of probation was entered in it was entered in spring of 2004, but then it was in November of 2004 that Mr. Rochell started serving the probationary portion of his sentence. He had a 1-month grace period as a supervision fee. The order didn't mention any of the other monetary obligations, which were restitution and maybe some fines or something. He didn't have a grace period on those that the record shows. But nevertheless, he paid nothing from mid-December, when the grace period would have run out of 2004, to mid-February of 2005, when he entered that offender financial obligation agreement. That's what they called it in Alachua County. And I think that the point that he entered that agreement mid-February and then paid $100 toward his first installment, I would agree the state can't show a willful and substantial violation of the monetary obligations after mid-February of 2005, but from mid-December of 2004 to mid-February of 2005, he didn't pay anything. And I think that's willful and substantial, and leaving aside all this problem with the reasonable suspicion of trespass and stopping the truck and so forth, the monetary obligations would be sufficient to revoke probation. We ask that you all affirm the order.
Well, of course, we wouldn't know whether or not the trial court would have chosen to revoke if we were dealing with monetary violations.
Well, the court said he found that all three different conditions that were violated were willful and substantial, as I recall. He violated them all, and in context, the court seemed to consider all of them willful and substantial. No, Your Honor, I can't say 100% that if that were the only violation.
The normal course there would be to send it back so the trial court can make that determination if we found that only monetary violations were involved. That would be what the normal would do.
That seems to be typical practice, yes, Your Honor. But with that, I would ask you all to affirm the
Okay,
order.
thank you, sir.
Thank you.
Mr. Rochell and Mr. Whitford can't help it if the people that they choose to visit live in a high crime area. That's not their choosing. They certainly don't label it a high crime area. That's someone else calling it a high crime area. They can't help that that's where, the sister and the friend live. Just a couple more points. Again, this thing about the trespass, there's got to be either actual or constructive notice. There were signs everywhere, but the signs did not meet what the statute requires. The statute is very specific. So I maintain that that there was not constructive notice, and certainly there was no actual notice. If the officer on the scene was so concerned about these men being there, he just had to walk up to them and ask them to leave, and they would have left. Certainly Mr. Rochell would have, because he's on probation. He sees a police officer, he'll do anything that the police officer asks him to do. And just one more brief point about the money. Yes, he reported, I think, in November, and he didn't pay until February. But I want to reiterate that his probation officer didn't ask him to pay anything. Mr. Rochell at all times did what his probation officer asked him to do. When he started to ask him for money, he gave him money, and he gave him money ahead of time. I would submit to the court that it's not Mr. Rochell's obligation to insist to his probation officer that he make payments. If the probation officer, it's his job to make the probation officer happy. If he can't make the probation officer happy, he knows he's in trouble. He does what he says. If the guy's not asking him for any money, it's not Mr. Rochell's. I suppose in a perfect world, Mr. Rochell would say, well, now, aren't I under a court order, to make such and such a payments? But the probation officer did not ask him to make payments until February, when he started to promptly pay. A very cynical person would suspect, perhaps, and maybe I shouldn't say this, but the probation officer testified that this was his policy. This was not an exception for Mr. Rochell. It was his policy not to request any money from the probationers until they filled out this form. A cynical guy would think, well, that puts kind of a violation, kind of a sleeping violation in that probation officer's back pocket that he can pull out and use any time he wants, because immediately his guy's in arrears. I hate to think that that's how they run their office. But Mr. Rochell always did what his probation officer said, and I believe even the probation officer had nice things to say about Mr. Rochell, except that he was in arrears. And when this other business came up, they look through the file and they find that he's in arrears, and so they add that as a violation of another condition.
All right. Thank you, sir.
Thank you.
Thank you both.